One of the most sobering things that Erika talked about, I think, was right at the beginning, and those charts on wealth disparities. And one of the major determinants of wealth is housing. Whether you own your house, what is the value of your house, and your value is generally determined where your house is, what is the character of the neighborhood, and everything. And all of that is tied very deeply into discrimination. If you want to do discrimination law, and particularly housing discrimination law, you are in the right place at the right time. Because Chicago consistently is listed as one of the most segregated cities in the nation. And if you don't believe it, just when you're going home tonight, look out your window, and I think it's visible to everybody. And I think it's important to remember when we talk about housing, this is the Martin Luther King Conference. And Martin Luther King's only major northern campaign was in 1966 in Chicago, where he led an open housing campaign and had marches in Market Park and Berwyn and other areas of Chicago. And historians generally say that that was Martin Luther King's least successful campaign. I personally think he accomplished a lot during that period and in terms of highlighting the problems of housing discrimination. But at the end of the summer, Martin Luther King was supposed to have said that he never saw such hatred as in Chicago when it came to open housing, that nothing in the South, Birmingham or New Orleans or no place, Mississippi, could match Chicago when it came to housing discrimination. Now, we all know that the very first civil rights law passed by Congress in 1866 specifically addressed discrimination in the ownership and leasing of property. So immediately after eliminating slavery and defining United States citizenship, the Congress said that the right of Americans to own or lease property free from discrimination on the basis of race is fundamental. And yet we know that statute was vetoed by the president. It was passed again. The 14th Amendment was largely passed to make that law constitutional. But it wasn't until 1968 that the United States Supreme Court finally said that that law was justified under the 13th Amendment. It didn't require state action as other statutes passed under the 14th Amendment because housing discrimination was a badge or an incident of slavery. And using the language in 1968, the court said herding African Americans into ghettos was a clear sign of inferiority, was a clear badge or an incident of slavery. So from 1866 to 1968, housing was fair housing, anti-discrimination in housing was really aspirational. And as Erika pointed out, the separate but equal doctrine, the state action doctrine, all the policies of federal government, state government, private discrimination conspired to create segregated housing, particularly here in the North and particularly in Chicago. Also in 1968, Congress passed the first Fair Housing Act. Why wasn't it passed in 1964 with the other civil rights laws? It was too controversial. In fact, if you might remember, those of you from con law, in 1966, or 1967, I think it was, the Joan Reitman versus Mulkey was argued before the Supreme Court. where it was argued that California could make the right to discriminate in housing a constitutional right. And that was generally the thinking in 1968, that people had a right to sell to whomever they wanted to. People had a constitutional right to rent to whomever they wanted to. The Fair Housing Act, in many ways, ended that. The Fair Housing Act prohibited discrimination on the basis of race, color, national origin, and religion. You might note that something is missing in there: sex. Congress included sex in the Civil Rights Act of 1964, did not do it in 1968. It wasn't until 1974 that the Fair Housing Act was amended to include sex discrimination. It wasn't until 1988 that Congress expanded the Fair Housing Act to include persons with disabilities and families with children. And frequently before that, discrimination against families with children was frequently based on race, color, or national origin. The 1968 Act was really revolutionary, but it had very minimum enforcement measures. So it wasn't really until 1988 that real teeth was put into the Fair Housing Act that enabled it to be effectively enforced. So again, you think of housing and housing patterns being established, and very little in the way of remedies up until finally the Fair Housing Amendments Act of 1988. One of the important things I think to remember about the Fair Housing Act is that the original Fair Housing Act had one clause in it that is not in any other civil rights law. And it addresses the problem Erika talked about in terms of affirmative action. Because the Fair Housing Act says that the Secretary, the federal government, federal agencies, all recipients of federal money have an affirmative duty to further fair housing. That has not been interpreted as an affirmative action requirement, because you can affirmatively further fair housing without so-called discriminating against white people or other persons. You can affirmatively further fair housing through inclusionary zoning, through inclusionary advertising, through inclusionary policies. The problem with affirmatively furthering fair housing is the first Secretary of HUD, George Romney, took it very seriously and started to really enforce it, and President Nixon quashed that. And so it really wasn't until President Clinton put some measures into affirmatively further fair housing, but it wasn't really until the final years of the Obama administration that HUD adopted a rule requiring local governments to receive federal money to affirmatively further fair housing, and to do that as a condition for receiving funds, and to actually submit a program to the federal government that would show how they would do that. It's probably not surprising that that has been one of the major targets of the Trump administration in recent years. But that is still the requirement. Even if the administrative rules enacted by the Trump administration are not enforced, there is still a duty of public officials to affirmatively further fair housing. The other thing that I think is important to recognize is that the Fair Housing Act has a disparate impact standard, much the same as employment discrimination. And again, Justice Kennedy, just recently in the Inclusive Communities case, recognized that long history of housing discrimination, and the fact that once housing patterns are in place, they're not easily erased. In fact, recent studies show that those areas that were covered by restrictive covenants in the 1950s and 60s and 70s, if you look at a map of where the restrictive covenants occurred and the racial makeup of those communities today, you can track segregation exactly by where there were racial restrictive covenants up until they finally became illegal in 1968. We know they became judicially unenforceable in 1948, but people could still do restrictive covenants so long as they didn't go to court to enforce them. So housing is a key factor in what Erika was talking about. It's important for voting rights. It's important for schools. Mm-hmm. Segregated neighborhoods produce segregated schools. It's important for jobs. It's important for transportation. It's important for everything in life. But it's also, to me, and what I see, we have a fair housing clinic at the John Marshall Law School, is housing discrimination probably does the most individual damage to people who suffer discrimination of any act of discrimination. You can be told you can't vote, you can be told you don't have a job, but it isn't quite as personal as you have the money, you go to rent or buy a home, and you're told you're unsuitable to own that home because of your race. That is directly against a person's dignity and has long-term effect not only on that individual, on their entire family, on the neighborhood, and everybody else. So think of housing discrimination, think of Chicago and what we need to do here in Chicago about that problem.